Can we ask a question?
Yes. Now, I've just started to record, so I'll just introduce first, Brad. But so this is laws.
Okay.
This is trusts and 12060. We're into week 8. This is John Milburn and Brad. Are you going to ask a question?
Okay. Yes, we were having a coloured discussion pertaining to the assignment, but the question I had was, you made a comment in, I think, week 4 or week 5, that said in your application you would seek a resulting trust, and in the absence of the court's finding for a resulting trust, you then subsequently seek a constructive trust.
And argue.
Is that correct? So on your submission you would have 1, you're seeking the resulting trust, and 2, in the absence of the court finding, you would then seek a constructive trust on the alternative.
It doesn't have to be in that order, but it's quite common to seek alternative remedies. So if you believe that you can maintain an argument for various different types of trusts, or an argument based on trust law or contract law and consumer law, you can always argue in the alternative and plead to that effect. The other thing that you can do is argue for different remedies. So it may be that in some circumstances specific performance is appropriate, other times a declaration, or it may be a claim for damages or an account of profits. And you can argue for more than one remedy as well. So I hope that answers your question, Brad. And I'm sort of intentionally not saying...
It does. I think it helps the others.
Okay, great. Thank you. Were there any other questions? And just for those of you watching the recording, I was late tonight, so everyone's been discussing things. Any other questions before we... Yes, Linda?
John, I've got one. B was saying that it's somewhere written on the Moodle side, I haven't gone looking yet, about the $20,000 first home buyers.
Yes.
That it was to be considered as part of the purchase price. But on the assignment, it doesn't have that. It just leaves it up in the air. So we're to consider that she put the $20,000 on the purchase price.
It does leave it up in the air in the assignment. And I must confess that I was working on an assumption. It's been a while since I've done conveyancing, but I had thought that the $20,000 was paid at settlement. The logic being that people need that money in order to purchase. Now, I forget who it was who said, look, I had an experience that was different to that. So on Moodle, and I think it may have been through you, Crew, I said, very happy for you to work on an assumption. And it's quite common. If you're preparing an opinion in relation to a certain matter, you may have to preface your comments based on an assumption of the facts as you see them. And alternatively, you can say, if this, if you feel that it makes a difference, you can say, if the money was paid as part of the purchase price, here is the appropriate response. If not, if the money came later, this is the way that it can be viewed. So I'm very happy that you picked that up, and feel free to have that flexibility. Thanks, Linda. I'm glad you raised that question. So I'm pretty sure that was on you, Crew, where we had that discussion. Okay, and thank you, Linda. Thank you, B. Okay, any other general
John,
questions?
can we be the devil's advocate, John, and
yes,
try and defend the son and daughter?
Absolutely. If you, actually, did I... It's a while since I've written that assessment. Did I write the assessment that you're advising a particular party? No? Okay. No, absolutely.
I think it said you can choose either. You can argue different.
Yeah, you said we could choose either one.
Either one.
Yeah.
Okay, great.
So I
that
choose
doesn't surprise me. That's the way I usually write assessment work, so that you can argue a particular angle. I do that quite intentionally because one of the themes that I've been promoting through this course, as I do other courses, is the fact that we're really here not necessarily to find the right answer, but to argue a position. And as lawyers, you're arguing plaintiff, defendant. It varies week to week. So, it's a good idea to argue from the different perspective. The other thing, it's not a bad idea to think of it from the other's perspective as well, so that in mounting an argument, you've got an idea of what you would do if you were on the other side and tried to counter that. A bit like playing chess against yourself, if you don't understand what I mean. That's a really good question, Aaron. Thank you for that.
John, in regards to the layout, I've looked at a submission, outline of submission, but I was wondering if you put in italics the issue and then went into what our submit. So, you might go point 1, 2, 3, and then you go in respect of the purchase or comments that were made. If we're saying an issue about comments that were made subsequent to the purchase, and then go through our relevant law and case law in support of our argument to make it a bit clearer in our submission, because I sort of looked through some submissions and I found it difficult to follow in some respects, because you sort of had to then work out, well, what was the issue they're arguing? And then they went through the relevant law and the case authority. And I thought if you had the italic as to the issue and then the next clause following on from that to help with the layout.
I think that's a great idea. I'm a real fan of headings. Headings, judges use headings, academic writers use headings. Any way to make your message clearer, I fully support. So that sounds like a very good way of doing it, Brad. And I forget who found it, but correct me if I'm wrong, but on UCrew there is a sample submission, outline of submission, and that was actually from Stephen Kime, who I'm in regular contact with Stephen, very good lawyer, and that was a submission, I think, in relation to an environmental law matter, if memory serves me correctly, which is another subject that I do. So that's a really good way of doing it, Brad, but it's not the only way. There's no necessarily correct format, but there are some basic rules of formatting, and I think you all know that I'm really keen on having something that just looks nice. Doesn't have to be over the top, but just consistent. Make sure you footnote reference. We all know that. We all know how to use the Australian Guide to Legal Citations. So, and if you don't, have a look at the back page. All right, so really good questions so far. This is great. Any other questions? I'm pleased that you all had a chat amongst yourselves. All good? And it's a good roll up tonight too. All right.
I think that'd be a good way to do a future assessment, John, is to have a real debate on Moodle.
It's not a bad idea. I like that. That's a good idea. I do have audio-visual assessments for some other subjects that I take. Introduction to Law, not environmental law, trust, no, we don't in trusts. Evidence and Proof, we do. And ADR. I take ADR.
ADR?
Yep, Brad, you did that last year with me. So ADR, we have a mediation or something.
Yes.
Similar. All right. Okay. So last week we left off talking about hearsay, and we got to a stage where I wanted to run through a case of Pollitt against the Queen. Now, does anyone know what Pollitt was all about? Pollitt against the Queen. So Pollitt, this was a case where Pollitt was charged with murder, and what happened is the Crown alleged that Pollitt intended to murder, let's say, W. But instead of doing it himself, he hired, there was a hitman was hired to do the job, and it was actually Pollitt was going to murder this fellow, but do it as the hitman, if you like. And the person who engaged Pollitt to do the job died before the trial. And before dying, this person made various statements to Mr. and Mrs. B that he knew all about the murder, and the wrong person was killed. Anyway, Mr. and Mrs. B were in this person's company when he received a call from someone, and during the call, the person who died was pretty angry and said to the presumably fellow on the other end of the line, "You'll get the rest of the money when you do the job properly," put the phone down and said that was Pollitt on the phone. So A, having died, obviously cannot be called as a witness. So the question for the court was, can we call Mr. and Mrs. B to give evidence as to what A said? Because it's clearly hearsay. So, and if you've seen Rake, you'll know that one of the stories in Rake was based on Pollitt's case, one of the weekly stories. So B says, yes, you can. All right, so why would we allow, great show, yeah. All right, so B says it's a phone exception to hearsay. So the High Court said, yes, that's true, and they ruled that the evidence of Mr. and B was admissible. So what did it tend to show? What did their evidence tend to show? And was it direct or was it circumstantial? B, it tended to show the identity of the caller. Correct? Was it direct evidence or circumstantial?
It was direct.
It was direct as to what was
direct
said.
evidence.
Yep, but it was circumstantial inference as to who was the killer. So it's a bit of a combination of the two. They actually heard it from what A said, but it was circumstantial inference evidence that it must have been P who was the person at the other end of the line and was the killer. Okay, so that was Pollitt's case. So what we've been talking about are various exceptions to the hearsay rule. And we have in Queensland a requirement to understand two sets of rules. So what are those two sets of, actually I'll say three sets of rules, but one is a subset of the other.
Hey, John, are we doing evidence here or trusts?
Oh, sorry. We're doing trusts, aren't we? Sorry.
That was really. Yeah, I'm wondering why you were talking about hearsay, and I'm thinking you're throwing us a red herring on the comments made by the deceased, and I'm going, that's not even relevant. I mean, why are you talking about that? Anyway, that's my argument. It wasn't relevant.
Oh man!
I was trying to connect it to the assignment. I think, what are you trying to tell us?
It's been
it was in regards to the comments. It was in regards to the comments made by the deceased to her daughter and son as to the gift, and I'm going, yeah, but that's not relevant in regards to a resulting trust, if that's my argument. I'm going, where's he going with this one?
That was a really cryptic one. How many of you do?
Was it Brown and Dunn rule?
Yes, Brown and Dunn. Excellent.
Oh, yeah.
All right.
If you're doing evidence and proof, you need that one for the exam.
Yeah, you do actually. Brown and Dunn is a perennial favourite when it comes to evidence and proof. So seeing you're not doing evidence, I can tell you all about the evidence exam. Don't tell the others. Who is doing evidence out of this group? Anyone? No? All right.
Quiet, Maria, don't say a word.
Maria. No, Maria, you're not doing evidence. All right. Just talk amongst yourselves for a moment. Thank you. Oh, I've done it again. I've gone back to, I've just got evidence on the brain today. Trusts. Well, now you know all about Pollitt's case. That's a bonus. All right, week 8. Liabilities of the parties for breach of trust. This is timely. In about week 8, I usually invite people to provide feedback. When the big red button comes on the screen, and I'm sure you all know about that, it's your opportunity to give feedback. And what a day to invite you to give feedback when I'm teaching you the wrong subject. So you'll really have some words to say about that. Okay, so last week we talked about the objects of a trust. We talked about beneficiaries. So this week we're building on that. We're considering the liabilities of parties for breaching the trust. And it flows on because we talked about certain powers and rights available to beneficiaries. Have you been finding the flowcharts useful? The flowchart for this week is 8.0. I like them. I didn't draft them. They were on the Moodle site ready for me to use, but I think they're a really useful way of doing it. Yes, Brad.
Can I ask a question on that? Has anyone worked out how to print them off? Because they're in a format that you can't directly print it. Do you just copy
Yeah,
and
Brad, copy and paste. Copy it
Okay.
and paste it to your Word doc.
Okay,
No,
I thought
actually,
so.
I just went to file and pressed print, and it just came out with this print view, and it just printed.
Oh, yeah, I tried that and it wouldn't do that.
I used a snipping tool, Brad, and just did a cutout of each one and then saved them individually.
Yeah, okay, cool.
Yeah,
I've just saved them files, so I'll see if I can work it out from there. Thanks for that.
yeah, that snipping
Print
tool.
screen.
is,
Okay.
Did Peter, you mention the snipping tool? I use that regularly. That's a really handy way of doing it as well.
Yeah, it's a good tool. Yeah.
Okay.
And can I also suggest when you've uploaded our tutorials, when you put it to YouTube, you can't convert it to an MP3 because it's against YouTube's rules. Because I was trying to download the Zooms to a USB so I could play it in my car, and you can't do that from YouTube.
All right. So it would be useful if I uploaded the MP3 version as well as the MP4 version.
That'd be excellent, because that way I can just whack it in the car and play it through the stereo system.
Yeah.
But yeah, so YouTube, when you try to do it, it won't allow you to do it. So I put in the question. The question comes back. MP3 is against the copyright rules of YouTube.
Oh, okay. All right. I mean, you can play it as an MP4 while you're traveling as well, but it probably uses a lot more data, I guess. Okay.
Oh, I was just trying to put it on a USB stick to be able to play it. That was all.
Yeah. All right. Thank you. I'll look at that. Okay. So we talked, actually, without realising, we were talking about damages as an equitable remedy. Is that a correct statement? Damages is an equitable remedy, or is damages a legal remedy? What do you think?
Legal.
A legal remedy.
I'm going to be a bit different here and say it's both. That you can apply for damages both at law and in equity. We don't think about damages being an equitable remedy, but I think it is. So just keep that in mind. We know all about other equitable remedies, the standard ones that you can apply for. So I'm sure we're all past that. So tell me about injunctions. What type of injunctions are there? There's two
The
basically.
interlocutory injunctions, prohibitory and mandatory.
Yes. Now, when we talk about interlocutory, that's not a direct, it's not in the same class of injunction as prohibitory or mandatory, is it? It's a different, we're talking different concepts there. What are the different concepts? Yes. Who was that, Peter?
Yeah, it's a temporary injunction until such time as it's heard in a court, where you've got to show that you've got a case, and that if you can show you've got a case, well, they might consider it, but you also have to have some money behind you in case it goes against you.
Yeah, that's true. Security for costs. So just to expand on what you were saying, B, when it comes to injunctions, when we talk about different types, within that concept, there are different types of different types. So the first different type of injunction that we want to distinguish between is a mandatory injunction or a prohibitory injunction. So essentially, an injunction normally is an order of the court to stop someone from doing something, to prohibit them from doing something. But it can also be mandatory in the sense that it is an injunction to compel them to do something. So it can have that negative as well as positive effect. So that's one distinction. The other distinction is the timing. And if it's an interlocutory or interim injunction, we're talking about something which is to put a hold on a position pending the trial. And at the trial, the injunction can be a permanent injunction. So there is the timing issue as well. So two different ways to distinguish between injunction relief there. And talking about the precedent of an outline of submissions, that was an application by Stephen Keim seeking an interim injunction in an environmental law matter as part of a case which ultimately sought, from memory, a permanent injunction as well. So I think the court ruled against the applicant in that case for the interim injunction, but ultimately allowed the permanent injunction 6 months later when the matter went to trial. Okay, so when we talk about a remedial approach, what are we talking about there? What's remedial mean? All right, so it's a compensation, isn't it? Yes, yes, B?
Like to make up for something?
Yes, exactly. What's the contrast to a remedial order?
Is that like, because it's like a remedial trust and an institutional trust. So an institutional trust, they say it's not sort of discretionary. If all the facts are fulfilled, then, you know, it's not so, yeah.
Yeah, no, that's true. But another way of looking at it is to say that the order is a punishment order. It's a punitive order, not just to put the applicant back in the position where they were to remedy the situation, but to contrast that, we talk about it being a punishment imposed on the wrongdoer, which is a punitive matter. So equity doesn't generally look to punish a wrongdoer or even strip profit from a wrongdoer. Now that has a ramification here in that if a person misuses trust funds and gains a profit, then it's not necessarily going to be the case that the court will look to provide that profit to the person who was wronged, but rather to put the person who was wronged back into the position they would have been had their wrongdoing not taken place. So it can make a difference. You know, to take a silly example, someone misuses $100 of trust money, puts that on a horse at, you know, paying 10 to 1 and makes a very large profit. Equity will be looking to remedy that situation by ordering the return of the $100, not the $1,000, if you understand what I mean by in that sense. So it's a remedy situation, and the damages claim that equity will award, coming back to an earlier point, is really based on the loss or injury that flows from the cause of action and is not awarded in terms of punishing the wrongdoer in that sense. Okay, injunctions, specific performances, performance actions. Generally speaking, it's there to give a remedy in relation to something which is actual rather than threatened. So if in equity there is the greater flexibility in terms of those remedies, but the common law is quite restricted in terms of those sorts of remedies. So to give an example of a case where there were equitable damages awarded, even instead of an injunction, have a look at Leeds against Cooperative Society against Slack. It's an old decision, so that's Leeds against Industrial Cooperative Society and Slack from 1924, AC 851. And in that case, the House of Lords held that equitable damages can be awarded in lieu of an injunction. And that was followed in Barbagallo and Catalan in Queensland, 1986 1 QDR 245. That was an injunction to restrain a neighbour's excavation activities from encroaching on their land. And in that case, the court awarded equitable damages rather than just an injunction. And I guess the point that we're really saying there is that there's a whole range of different remedies. You need to consider the loss, and you need to consider whether a court of equity will truly compensate a client for that loss. Now, what's an alternate action where you actually do want to claim the profits that may have been generated by the wrongdoer. What's that action called?
An account for profit.
Exactly. Yep, account for profits. But you've got to make a choice, don't you? If you're a claimant for a wrongdoing, you've either got to claim compensation, which is the default position, or an account of profits. And a beneficiary can bring an action for account of profits, but they can't then claim equitable compensation as well. It's one or other. So you've got to make your choice at that stage. So when would you, as a plaintiff, likely choose to pursue an account of profits? As I said, you can't always do this, but when you can, when would you choose to do that?
When the account of profits is going to be greater than the compensation.
Exactly. And you look at the results then and see what will happen. And if there is that greater payment of greater income which is generated, then you will claim that. So it's not always available. But, yes, Brad?
John, so would you also, in the event where you can't amend a transaction whereby a third party now has purchased, say for example, they purchased a property off the person who breached, you can't then seek an equitable remedy from the third party, so you would then seek an account of profits from the person who breached. Is that correct?
I think that's a fair comment. So in terms of the first part, you're really talking about, say, a tracing action where a bona fide purchaser for value has acquired property. You really can't trace the property at that stage, but you may be in position to seek some sort of account of profits. Yep. Now, an account of profits, I mentioned that it's generally not available. It's limited, and there is some crossover with common law principles. So the concurrent jurisdiction for an account of profits between common law and equity might be in relation to things like partnership or agency, or I think B mentioned it before, intellectual property or industrial property cases. So look to see if there has been a breach of an equitable obligation, and an account of profits will flow from that. So in Warman against Dwyer, 1995, the High Court said that an assessment is difficult and will not be subject to mathematical exactness, but only a reasonable approximation. And we see that a lot. Now, I mentioned that I'd take environmental law, and one of the big issues for environmental law is a thing called standing. What do I mean by standing? Standing to sue.
You have a right to sue, that you have a right to appear in court to sue.
Exactly, that's it. So the court isn't available just to anyone who wants to know the answer to a legal question. You must have standing to sue. So where you have a breach of trust, obviously would be perhaps a beneficiary, might be a person who can bring an action. And we'd look at Section 8, I think, of the Trust Act would be the first place I'd look. Who else would have standing to seek an order of the court in relation to something that a trustee has done wrong?
Fellow trustees.
Exactly. It was at you, Peter. Exactly. So co-trustees can do that as well.
Yep.
All right. And the remedies are usually such that the trustee is personally liable for the consequences of a breach of trust. And the main remedies are equitable compensation or the account of profits, where we've discovered you need to make a choice. So, and it gets a bit tricky, doesn't it, when the trustee uses some trust money, mixes it with his or her own money, and it's then a matter of trying to unravel situations, particularly if a bona fide purchaser for value is brought into the equation down the track. All right, so we mentioned co-trustees. having a right to issue proceedings against a trustee who's doing the wrong thing. As far as beneficiaries are concerned, can the beneficiary claim money against or loss against both the wrongdoer as a trustee and the other trustee? Let's say there were two of them, the other one who didn't do anything wrong. What's the general rule there?
No, I don't think so. Can you? They can't be.
Where's the first place that we'd look to
They're
find
act-
the answer?
Trust Act.
Yeah, even before that. I know I've been ramming down the saying Trust Act, but even before that.
The trust deed.
Yes,
The trust
that's
deed.
it. The trust deed. Thank you. I think B and Maria got in equal time on that one. So always have a look at the trust deed, because there might be something in there. There could even be an exemption clause that the trustee seeks to rely upon. But you then look at the Trusts Act, then you look at the common law, do it in that order. Okay, so if you were a trustee and you're under attack from a beneficiary, what sort of arguments would you put forward to repel the arguments made against you?
You sort of behave honestly in good faith to the standard of a prudent business person, or you sought advice from a recognized special person who gives advice.
Yes, they would be excellent things to think about. And again, there might be something in the trust deed, there might be something in the Trusts Act. What other sorts of arguments can a trustee put up against a beneficiary or even a co-trustee to say, no, not liable?
What about, I think it's called lashes? The time has expired, they haven't come forward soon enough?
Excellent. Yes, delay, latches. It's an equitable term, and that's a good one. So if you're looking at a problem of this nature and you see that there's a considerable time delay between the alleged wrongdoing and the action, think latches, think what's in the trust deed, think what's in the legislation. These are really good points. What other things could a trustee put forward in defence to a claim against them?
They had fully informed the beneficiaries about it, and the beneficiaries had agreed to the act.
Excellent. In other words, just because a loss was sustained, that doesn't automatically mean that some sort of strict liability, that the trustee is going to be liable. In those circumstances, it may be that the beneficiaries knew and consented. What's one level down from outright consent that you might be able to argue successfully as a trustee?
Constructive knowledge. They ought to have known. Is it like the...
Yep. That's really good. Remember we talked a few weeks ago. Was that acquiescence?
Yeah, I can't quite pronounce the word properly, but that's the word I was trying to think of.
Yep, I love both those arguments. So B's argument was that there is a constructive knowledge, and that really goes back to the basic principle that the courts are there to respond to someone who comes to them to say, hey, there's something wrong here. And that means they rely upon beneficiaries to bring that action. Acquiescence is another good one, in that the beneficiaries may not have outright consented, but they didn't object. And Maria says silence, doing nothing. And in some circumstances, silence can be acquiescence. So that these are all arguments that you might put forward. I honestly can't remember if it's in the exam, but it would be useful to start constructing a list of these sorts of things so that you've got a few things that you can argue in your case. The other thing is that and I mentioned, I think briefly, when you're looking at the trust deed, look at exemption clauses. So that's a substantial one for trustees to repel actions against beneficiaries. Not always going to be successful, but they might be. And finally, just bear in mind that courts have an overriding discretion to excuse trustees from a breach of trust. So it may be that, and I think someone mentioned it before, that you can argue you acted honestly and reasonably. Remember the Trusts Act, section 76 in that regard. Or it may be that the court can excuse the breach of trust for other reasons, such as proper inquiries and advice. I think B made that point. Or they engage someone to assist them in terms of providing some expert advice. So have a look at Reinvestor Properties from 2001, 187 ALR 462 in that regard. Okay, well, you've done very well tonight. Section 76, Erin, thank you, that's the one. I know that you've been online for a long while, longer than I have. We might call it quits at that. I know it's a relatively short session in terms of a formal session, but it sounds like you were having a great chat. All right, so do you have any questions before we wrap up for tonight?
Just now, when we were discussing, someone's mentioned that, you know, the court wouldn't award interest. And I was saying, I thought that they actually do. In fact, the argument is between simple and compound, and most of the time they would award simple interest and not compound interest.
I agree with you there.
But it's been known to happen.
No, I agree with you there. When we talk in terms of compensate, you know, putting them back in a position, the time that they've lost that money should also be compensated to properly put them in that position. So therefore, it would be interest. Now, I'd be surprised if a court denied a claim for interest in circumstances where someone was successful for equitable damages. Maria says, do we know
also,
about
I found that, yeah, the exam dates, I think it's on the 7th, was it the 8th of June?
Yeah, it was really early.
Yeah. No, the other thing is I was reading Muschinski and Dodds, and they had this thing called an order of sale. Is that a mandatory? Does it come under a mandatory injunction, or what is an order of sale? Is it one of the remedies?
Yes, look, I remember the name of the case. I can't remember the exact circumstances, but that does sound to me like that is a mandatory injunction, which is to compel the doing of something. So, yes, that would fit within that category more than likely, but I can't remember the exact circumstances. Sorry, B. Really good questions tonight. You're all thinking.
John, can I just ask, I wasn't at the tutorial last week, but I listened to it, and you were talking about family law and trusts and what the family law can look at in terms of trust. And I was thinking about it, is it possible for the family court to say that if children are, let's say, property in or money or whatever in a discretionary trust, can they look at that in terms of maintenance of those children that needs to be paid?
Yes, I guess my comments were essentially with respect to the way in which the court might consider trusts as a financial resource as between parties to a marriage or de facto relationship, section 75-79 of the Act. But within that context, maintenance can still come into play as far as children are concerned as well. But I was really talking more in terms of the relationship between the parties to the relationship. I hope that answers your question.
Thank you.
And
yes, thanks.
8th of June, we're told, is the date for the exam. All right. Look, thank you very much. You've been very patient with me tonight. Appreciate that. Brad says Family Law Act doesn't allow an order to establish a trust, section 85 or 88. Okay, yep, Thank you. All right. Well, we'll end the meeting tonight. If you're joining me for evidence, you know all about Pollitt, don't you, Maria? All right. See you then. Bye.
Thanks, John.
Thank you.